Hello and welcome everyone. I am Kristi Dosh, founder of Business of College Sports, and I have been bringing you a series of webinars as we get ready for NACDA Convention 2024, talking about some NIL and sort of related player compensation kind of issues. And we decided we wanted to jump on and do a webinar sort of in reaction to the initial ruling in the Dartmouth case. And we have now seen the team vote to unionize and seen that certified by the National Labor Relations Board. So I am thrilled to welcome back Ksenia Maiorova, who you all have probably heard from before on one of our webinars. We've talked a lot about international athletes, and we'll talk about how this decision impacts them. Ksenia, thank you for joining us again.
Thanks for being with me.
And then Ksenia introduced me to John Mazzeo, who is going to join us to chat about this as well. He has brought up all sorts of employment related issues that I hadn't even thought of yet. So looking forward to learning more from both of you. Thanks for joining, John.
Thank you for having me.
So I thought we would just start with sort of initial reactions to what's happening at Dartmouth. At this stage when we're recording this, the players voted to unionize. The NLRB has just certified that within the last couple of days. That's kind of where we're at with that. And Ksenia, I want to start with you because this is something I've seen you say over and over and over, and I still meet a lot of people who haven't heard it yet. But Dartmouth's team has 4 international student athletes. How does a decision like this impact those international student athletes?
So I think we have to kind of go off of some assumptions here, right? And identify the assumptions we're making. I don't know the specific immigration status that each of those athletes holds. We are only going off of their, listing on the roster as being from a different country. And I would say that it's a safe assumption that they are most likely F1 student visa holders, but there may be other scenarios which put them in a different silo and have different implications. But I would think it's also safe to assume that at least one of them is most definitely an F1 holder. It would be highly unlikely that all 4 of them are holding something other than an F1. So I think that the implications are there regardless of the assumptions that we're making about status. And so with the F1 is a visa that severely limits the type of employment that you can engage in the US and typically aligns those employment opportunities with your course of study. So a postgraduate internship or an internship that you do during school that has to match your area and major field of study. And we also have on-campus employment, which can be authorized for up to 20 hours a week. That's an area that we might be able to play with down the road. But fundamentally, this decision is incompatible with this concept of the F1 visa because the F1 visa is at its core a student visa. And even though there are some employment authorizations that could be obtained under this visa classification, they have to be obtained, right? They have to be approved by a DSO or an employment authorization document has to be on hand for them to engage in this employment. So with them basically holding themselves out as employees by taking this vote to unionize because you can't unionize unless you're an employee. And with the NLRB's decision, we have a situation where they have both affirmatively stated that they're employees and we have a body that has found them to be such. And that has potential implications. Particularly risky is the concept of visa renewals because consular officers have unlimited discretion to deny visas. And even though there may be some arguments for, again, compliance under different areas of law, depending on how everything is structured, how they're paid, what they're paid for, the amount of work that they're doing, et cetera, which is still all unclear. The consular officer can still take the position that this is just incompatible with the F1, and their opinion is unassailable, meaning that there's no appellate review for their decision. And if they take the position that this is incompatible with the visa classification, they can deny and they don't have to explain the basis for their denial, and their decision is not subject to appellate review. So that's a major risk factor for these student athletes who may be required to renew their F1 visa stamps abroad, or may be seeking I think the less risky scenario is an extension of status in the U.S. I think USCIS is not likely to be as conservative of a take on this position, but it's not clear. And I think, as I was telling John in some of our previous meetings, my advice ethos is I have to identify a risk. I have to explain that risk to my client, and my client has to identify their level of risk tolerance, right? So there are certainly attorneys out there who have opined on this and have said, we really don't feel that there's a whole lot of risk there. It's still very unclear. Again, for me, if there's even a minuscule amount of risk with regards to the consular officer making a decision that may very well not align with black letter law, they still hold the power in that situation, and there are still adverse consequences that could happen for the student athlete and that we have to advise the client or the stakeholder of. And so, my current position is that there's some risk with this. The consular officers may not look at this in a positive light and may refuse to issue a visa stamp in the F1 category and may potentially even block future visa applications. And I think that's the more pressing problem, right? Is as immigration attorneys, we are concerned with our clients' long-term prospects in the U.S. I don't want to do anything or advise my client of doing anything that could potentially cut off their prospects of a future professional career. So if I'm talking about a basketball player who will eventually go into the NBA and potentially apply for a P1 visa through the NBA, we don't want to create a situation where, there's already something on the record that could put that potential visa application at risk as well.
Right. And John, do you share a similar opinion, or you have anything different to add?
No, I certainly think the risk is there, and much like Ksenia said, I'm very much in the camp of, as an attorney, even if I'm not advising clients, particularly, you have to highlight the risk. And I think one other place, and I'm interested to hear Ksenia's thought on this, is the consular officer issues, person presents at the port of entry, and they have, Dartmouth basketball, and the CBP officer says, well, are you coming to study or are you coming to play basketball? And is there an issue there? And that's something that just, had popped in my head as we were talking about it. And I do believe that, obviously recognizing the athletes as employees is very important, but the unionization issue, as we'll talk about later, adds an entirely new layer of complexity and risk around the entire student athlete / employee and university or college relationship that I think really hasn't been fleshed out yet.
Yeah. We're going to talk a lot today about how universities can prepare for a lot of different scenarios we're going to go through. But I don't know the answer to this. I haven't asked either of you before we started recording. I'll start with you, John, this time. When does this decision become potentially problematic for these international student athletes? So the NLRB's initial decision is their employees. They've now unionized. The unionization's been certified. Dartmouth is obviously appealing. At what point do international student athletes need to worry about their status? Because they're not being compensated as employees or treated like employees outside of, I guess, the control that the NLRB has found that the schools already had. So at what point does this start to become a real issue for them?
I mean, if I were a student athlete, a foreign national student athlete, I'd be worried now.
Okay.
Just because of all of the ripple effects. And to go back to something Ksenia said, that consular officer has unlimited discretion. So, say Dartmouth wins their appeal of the NLRB decision, and, the higher court says, hey, they're not athletes, or not employees, they're student athletes. That consular officer could say, well, you know what? I really liked that rationale. I'm going to believe that rationale. And in my unreviewable discretion, I'm not going to issue.
Okay. That's scary.
Yeah, I mean, I
really.
agree with that take. I think, some attorneys are taking the position that they shouldn't be scared yet because all of this is being appealed and it's an unsettled issue. Again, I think my position is a little bit more conservative and aligns with John's because, even if ultimately the courts say you're not an employee and you need to stop, affirmatively presenting yourself out there, holding yourself out as an employee, and the school is not going to treat you as an employee. If there was some period of time when you were in fact an employee, I'm not aware of any doctrine of timely retraction when it comes to a status violation. So even if the status violation was not long lasting, again, I'm not aware of anything that could cure it down the road if, they ultimately say, oh, no, you can't do this, and they stop, right? So I think the fact that there's just this fundamental incompatibility with saying I'm an employee and holding yourself out as such, and a status that does not allow employment unless specifically authorized and within the silos of authorized employment, I think we have a problem now. And I certainly hope that there was a contingency plan in place for these athletes and that they're getting good legal advice.
So if one of those athletes was your client, would you tell them to stop appearing in games once this decision was made? Does that help? Like, does that help them say, look,
No,
I'm not an
I don't know
employee?
that it helps. I think we're there. I think the
Okay.
snowball is rolled, right? And I think that, what I would have done if these were my clients is try to transition them before all of this got started into a status that allows them to be employed, something like a P1, and then said, okay, we're going to seek this designation as employees. We're going to vote to unionize. And at that point, there's not this fundamental incompatibility that we have with the F. The P does allow employment, and it would be, a novel use to some extent of the category, but we've been getting P's approved for international student athletes in the NCAA, so we know that that works. And so I think, to John's point, it's all about anticipating what could happen, anticipating the consequences, and developing a strategy at the outset that addresses the ripple effects of what they have undertaken here.
This decision obviously was just about Dartmouth men's basketball, but many of the things that they brought up as establishing that control necessary for that employer-employee relationship would be true of probably all the other teams at Dartmouth and probably most teams across the country, especially in Division I. We know, well, at least I know, for those of you who don't know, the NLRB decision only applies to private institutions, not public. So there's another case on the West Coast seeking a joint employer decision with the conference and the NCAA that could allow it to apply more broadly to public schools. But putting that case aside for a minute and looking at just what we have in the Dartmouth decision, should athletes at all private schools on all teams who are international athletes be worried, or just Dartmouth men's basketball right now?
I think to the extent that there hasn't been an affirmative step by the team to unionize, and by the university to classify the athletes as employees, I think we might be in a period of lull that is semi-safe. But again, this is an interpretive issue, and consular officers are not lawyers, and I would not be able to articulate a compelling legal argument in this regard without doing some research on, the nature of how binding these NLRB decisions are and who they're binding on. And, I'm an attorney with 17 years of experience under my belt. The average consular officer is not an attorney. And many of them are people that have, received 2 weeks of training that just want to go into the foreign service and want to eventually look back on their stint at the consulate as a bad dream. But they're all required to go through this as a part of their foreign service training. And so, there may not be that commitment to truth finding, if you will, that we have and that we're motivated to have because of the people that we represent. So I think it's unclear.
John, we talked a little bit before we hit record about the fact that a lot of schools are not having in-depth conversations about how this continues to play out. It very much looks like we're on this path toward at least some student athletes being employees. And a lot of folks just want to say, well, it's not really going to happen. We just took a really important step toward it happening. So I want to start talking sort of about, if you're advising a university, What are some of the key things they need to start doing right now? Because I don't think anyone has any idea what that next step even should look like.
Yeah, I think as a first step, you need, as a university here, you need to determine what your level of risk is and what your goals are. Everyone's going to say, okay, when this happens, we need to put policies in place around it. And what's going to drive those policies? Well, it's going to be what your risk tolerance is and what is important to you as a university. Is it going to be, putting the best starting five on the floor that you can, regardless of where they come from? Is it going to be, having sort of inculcating a group that goes out and has fun? How important is athletics to your university, and how important are foreign nationals to that? And even on the flip side, Ksenia has done some really great work on the foreign national aspect of it, but this really touches whether or not you are a foreign national student. If you just have a group, your 15 basketball players are United States citizens, born here, no employment issues, no visa issues, you still have to think about what is our process going to be for onboarding them, their Form I-9, their E-Verify issues. Who's going to take lead on that? I mean, athletic departments, to my knowledge, even the larger ones, don't have their own sort of HR group. So really, and they're the ones that are going to feel it the most. And the unionization issues just blow my mind. At this point, and we'll get to it, but it's really, universities need to get working groups together, someone from HR, someone from executive leadership, someone within athletics, including the athletic directors, who are going to be responsible. But you really have to start thinking, what are our goals? What are our risk factors? And how do we take all of our different opinions and different goals together and sort of chart that course for the next 5 to 7 years?
I don't know if this is the right question to ask, but one thing that comes to mind for me, especially or in relation to the international student athletes, is, obviously people who aren't students come here on work visas to work for major companies. What is that a possibility instead of like the P1s and the O1s, like you were talking about, Ksenia, which we've talked about on past webinars, if people want to listen to how athletes are getting those? Can you just switch from being on an F1 to being on a work visa instead? What does that look like?
So the P1 is technically an employment-based visa. So that does put you in the classification of the employment-based universe. If you're talking about something more classically employment-based, such as an H visa, which is, sort of the most utilized classification of employment-based non-immigrant visas, it doesn't really work for the most part, because what we're talking about is a classification that at the H-1B level requires you to demonstrate that it's a specialty occupation, right? H-1Bs are not my area of expertise, but my guess is, collegiate basketball is not going to be designated as a specialty occupation, because those are typically occupations that require a minimum of a bachelor's degree in a specific field. If you got a little bit more creative, went down to like an H-2B for a seasonal employee, seasonal peak load need, non-agricultural, you might be able to articulate some arguments there. But I actually don't know off the top of my head, without double checking the who can study chart, whether an H-2B can go to school full time. So even if you manage to designate somebody as an H-2B, a seasonal employee, I'm not sure that's necessarily a workable solution. And, there may be limitations on that I'm not thinking of off the top of my head. So I don't think that that's going to be the direction this is going to go. Ultimately, if we're looking for something in the law that kind of hits the closest, if you will, I think it's probably the on-campus employment authorization that exists under the F1. However, that would require some pretty serious tweaks because, on-campus employment is currently, sort of classically thought of as working at the dining hall or the library. ICE interprets that to include services that are rendered to students, right? And I think that while there's an argument that there's a benefit to students from the existence of college basketball, I don't know that we can make the argument compellingly that this is a service that is rendered to students. More problematically, we have the off-campus, potential travel and training and such. And so, again, I think there would need to be a pretty significant modification via policy or regulation to make that specific type of employment authorization kind of available to student athletes, and to maybe try to use that category to provide a fix. But as we've talked about previously, there doesn't seem to be an appetite for any of these mechanisms at any level, right? I think, in Congress right now, the current composition of Congress is such that nothing that has the words amend the Immigration and Nationality Act will pass anytime in the near future. On the regulatory front, rulemaking is something that is a complex, tedious, and long process. And, we have informally heard that they're not looking at this through rulemaking just because it's going to take too much time before the end of the administration. So they're going to see if they're going to get reelected. And on the policy front, while a policy fix is perhaps the easiest to accomplish, it's also the least durable. So to the extent that we have an administration change, it's something that can easily be pulled. So, it's an imperfect situation at best.
You mentioned briefly playing internationally, and we see like basketball tournaments in the Bahamas, and we've seen more and more schools having these tournaments or games in other countries to give college athletes that experience of traveling somewhere else. But how is that potentially problematic for these international student athletes, assuming that they are allowed to continue to play here once they're employees? Are there issues traveling internationally?
So U.S. immigration law does not have extraterritorial application. So I think that the issues that would arise if they're traveling internationally is, are they violating the immigration law of the jurisdiction where they're traveling and playing, and potentially engaging in other types of related activities such as content production. So I think that doesn't necessarily directly implicate U.S. immigration law.
Right, but and the flip side is, and we're here largely talking about the foreign national student athlete, but if I think what we said, Dartmouth had 4 international students, so figure they carry 15. There's 11 others who, if they were ever to go abroad and play in the Bahamas or in Europe, schools at least need to have a conversation of, okay, we're going to land, in Nassau, or we're going to land in London. Are our students / athletes / employees going to be admitted? Because we're all we are employees going to a foreign country to play a sport and earn money. I think we saw, what was it? There was one of the NFL, was it a punter this season who actually was he was stuck abroad. He was a foreign national. I think he was stuck abroad, but you could very easily. There was a performance artist who has a criminal record in the United States, a United States citizen, went to go abroad recently and wasn't admitted. So I think those are things that the theme here is going to be, prepare, plan. There are very few things besides those things that Ksenia has highlighted where we can't plan and handle. We don't know what the consular officer is going to do, but these are all conversations that schools need to be having, and it really is going to impact. I mean, I for sure would love to go to Battle for Atlantis one year, but are schools going to want to go play if they have to engage immigration counsel and risk, not? There's just way too much at stake to not have that conversation.
And what's the liability to the school as the employer if
That's
they
what I was
give the student athlete advice that they can go and they can do this, and the student athlete gets deported or detained or, is no longer able to access that country in the future because they have a violation on their record. There are certain countries that are very strict about stuff like that. Unauthorized employment can be extremely problematic and can be pretty much a lifetime bar to certain jurisdictions. I was on a panel of sports immigration lawyers representing multiple jurisdictions in London at the International Bar Association, or I'm sorry, Paris at the International Bar Association conference this past fall, and we were kind of talking about, well, what are the consequences of criminal activity or past immigration violations? And for some countries, it's incredibly strict that, you just cut off your ability to ever visit that country ever again. And that may affect their ability to, go in the pro leagues in that country if they're not able to make it into the NBA. Maybe they want to go play basketball in Europe or Asia or wherever. And if their college or university sent them on a trip there that got them deported and banned from that country, that's extremely problematic. And there may be liability issues and potential claims against the university for putting the athlete in that position and requiring that trip without, properly doing their due diligence, I suppose.
a lot of new stuff to think about, and we're not even partway through my list of things to think about. John, you brought up the unionization issues, and I'm not even sure I know enough to ask you the right questions about it because this is a new area of law for me too. So what are some of those big things that you're thinking about right now with respect to the unionization aspect of this?
Yeah, absolutely. It's one of the largest things is what under the NLRB and the way that the current board and the current general counsel is interpreting the actual act. What conversations can you have with employees who seek to unionize, and what can't you? I mean, I'm not going to take a political position, but I don't think anyone would argue with me if I say that the current constitution of the NLRB and the current general counsel is very active in promoting unionization, promoting the rights that they believe the act confers on employees. So it really runs the gamut from, okay, can this statement that a coach makes at practice, at the end of the season, be constituted as, an anti-unionization statement? Or are we going to see a CBA? How do we engage in that? Process is really tricky, and it ties back to that thing of the changing nature of the coach, university, and student athlete employee relationship, and it's really fraught, especially under this administration and their priorities. It's especially fraught because they're not afraid to bring in action.
It's a lot to wrap your head around, especially knowing that we've got the other case involving USC out on the West Coast, where for those who don't really understand how that case has bigger, different implications, and labor and employment law, not my area, but my understanding of it is that they're seeking a joint employer designation for either the conference or the NCAA or both, so that it's not just USC who's technically the employer, it would also be the conference or also be the NCAA, because then that would allow that decision to apply to student athletes across the country, even at public universities. And about half the states, by my understanding, don't allow employees of public institutions to unionize. But if they're employees of the conference or the NCAA, that could potentially look really different. So I don't want to get down a rabbit hole of like that case, but this goes so much further than Dartmouth, because that's more limited by the NLRB's jurisdiction. So that we could do probably a whole nother webinar about what might happen with the USC case, but a lot of moving pieces for us to all kind of think through. And I think, I want to help kind of high level, because we can't make this like a 4-hour webinar for you guys and hit everything, but the types of conversations that you all should be having on your campuses around these issues. So we've talked about the immigration issues and, kind of touched on some of those unionization issues. We've talked a little bit about liability. I thought maybe let's spend a little time diving into some things I've already seen brought up in the media around things like benefits, health insurance, pensions, how a student athlete might be terminated, what scholarships look like going forward. There's a lot of different things to hit on there. Any advice, John, on like where to start those conversations on campus? You mentioned before, bringing in those folks from HR, which obviously makes a lot of sense, but what are some high level issues that our conversations that would be smart to start having now?
Right. It's right now, the number one conversation, aside from operational issues that we've talked about, is how are we going to structure our relationships with these, students / athletes / employees going forward? And does that require us to change the way we offer scholarships? Does it require us to change the way that we have our, national letters of intent? Does it change the way that that athletics and administrators handle one-on-one students? So that's, number one, how are we going to, within our power, define that relationship? And it really gets into, the USC case being state pensions, state benefits. At base, they're employees. They are now state, not now, but assuming that USC comes through, and we now start seeing someone who plays football at Florida State be a state employee of Florida. What does that pension system look like? And really, what does that pension system look like as it works with foreign nationals, period, full stop? Also, the benefits. What about health insurance? Are you going to say, if you're a private institution now, you're going to say, okay, we offer all of our employees health insurance, but we're not going to offer, any athlete or these specific teams. Well, how does that work as a policy matter? And then to extrapolate it even farther, you say, okay, it's easier. Everyone's an employee. Everyone's going to get health insurance. Well, as a university, that's going to fundamentally change the risk factor of you as a health insurance client. So what is that ripple effect of your insurer now coming to you and saying, you know what, your premium's going to go through the roof? Because now it costs us a lot more to insure a football player than, just a group of academics. Not saying academics can't have injuries or what have you, but, those all happen. And then termination. I mean, this is something Ksenia and I talked about last week is, right now, and I think it was an employment law case with like Ole Miss, or I think it was Ole Miss or whomever. Football player is dealing with some stuff, goes to the coach. The coach essentially says, toughen up or get off the team. And I think the way it played out, and I haven't read it in a while, is they brought a retaliation claim, or an accommodation claim. Okay, transpose that now. Everybody's an employee. If this person or this athlete is not performing, right now you just pull their scholarship. You know what, fine, catch you later, go enter the portal, go somewhere else. Well, if they're an employee, how does that work? What law gets applied? And really, we have to determine that along with the institution's appetite for risk before we then take that step forward to, building a policy around it.
Ksenia, anything to add to that as far as figuring out benefits and that working relationship piece of it?
Not from my perspective as an immigration lawyer, but I think it's just fascinating. I mean, it's going to implicate everything from, potential employment discrimination lawsuits, right? And then the difference between at-will employment states and not, right? And what rights the employees have in each one, and how we actually create some sort of uniform landscape in a conference, for example, where there's a collection of states that have different policies, right? I think it's going to be really interesting for women's sports and Title IX, and the application of that, right? What about intersex athletes and potential employment discrimination claims there? I think that there's just a whole can of worms that opens immediately that, it ultimately, this is about ripple effects. And this touches so many areas of law, and it behooves institutions at this point of time to sit down and think about every possible legal implication and develop, hopefully at least the outline of a contingency plan of how they're going to deal with this. I mean, from my perspective, one of the questions that I have for John is, if we say, here's day one, they're designated as employees, what is the window that they have to comply for onboarding? How long is there a grace period? How long do they have to get all those I-9s in order? I think that's a question that's very pertinent to stakeholders in this space.
And it's sort of, with I-9 being sort of one of my specialties, it's a darned if you do, darned if you don't mentality, because if you decide, okay, this is coming, and I am X university, and we have, under this logic, we would now have 8,000 new employees, and we're not going to be able to do, assume that the I-9 regulation is applied in a way that is employer friendly. And they say, okay, the day the decision comes down is day one for employment, and then your 1 in 3 day compliance window starts. If I'm a university, I'm going to say, I'm not going to be able to do 8,000 I-9s in 3 days. So do I start doing them now before it formally comes out? And well, if I start doing them now, the argument's going to become, well, you made them do an I-9. I-9s are only for employees. That's proof that you even saw them as employees. So it's really, it is difficult to grapple with. And that's something that, with every sort of change in the law, we've seen this very active litigation. We saw years ago with like Uber and Lyft, people who were independent contractors being called classified as employees at one rate or another. And we recently saw the new independent contractor test come out of, I believe, the FTC, that's going to make it more difficult to classify someone as an independent contractor. These aren't just university specific issues, but it's incredibly important for the university because, to shed a light into the I-9 space. If you have an I-9 violation or an E-Verify violation, in addition to the monetary fines, the reputational issues, there's also debarment there. And if you're not able to access grants, if you're not able to employ foreign nationals, your ability as a university to function is going to really jam up.
Yeah, that's a good point.
Not to be a Debbie Downer, but...
I want to change gears a little bit because there was one more question I really wanted to ask you all before we sort of time out here. There's so many ways we could go with this. We're probably going to have to do a follow-up webinar, but one thing I've been hearing a lot on campus before the Dartmouth decision was folks saying they could get on board with a revenue sharing model. They just really couldn't get on board with athletes becoming employees. And a little bit of that conversation has to change because of what happened at Dartmouth. But there's still a real call for that revenue sharing model as well. Let's pretend for a minute they're not employees and forget about the employment issue for a minute. For international student athletes, what are the implications, or how would that work if student athletes are getting cut in on media revenue? Would international athletes even be able to accept that?
So I think it comes down to kind of the same issue that we have with NIL, right? And the Dartmouth unionization issue and this idea that they now may be treated as employees is just a different avenue to get to the same basic location. And that basic problem is that, immigration law defines employment slightly differently than labor law, right? So labor is all about like sort of control and things like that. The immigration definition is not particularly helpful. It's more focused on, are you rendering services that are typically compensated, right? And are you getting compensation, even in-kind compensation, deferred compensation, any of those issues can really, whether under the direct letter of the law or in terms of how USCIS or other agencies apply it, can get you in trouble, right? So I think that to the extent that there remains any element of quid pro quo that is tied to financial reward, we have a problem, because of the way that employment is defined in immigration law. John, would you agree with that? You were on the enforcement side of things. I mean, I think like, your position should be more aggressive than mine in many ways, right?
No, I certainly do. I think, and really what it comes down to with enforcement, and I think this is something that Ksenia, you've highlighted really well, is within immigration, no one's going to amend the act. USCIS is not in the position, I think, to start promulgating new or changed regulations. So the people who are going to be setting the policy and setting the risk factor are the line consular officers, or the ICE enforcement and removal operations officer, or Homeland Security investigations, or the ICE trial attorney. I mean, when I was sort of with the agency, something that you brought up is the unauthorized employment being a bar to remaining in the United States or having a visa issued, even in a different type. Even if you work for a day, right, it's going to trigger the bar. So I think at the end of the day, the employment issue is interesting, right? Because, okay, the NLRB is going to say what they're going to say. But also, as it pertains particularly to foreign national student athletes, I'm really worried about, the line officer who's going to really be setting the course. That's who you're leaving the power in the hands of. In the absence of regulation and policy, those are going to be who sets the tone.
So much to think about. Like my brain feels like it's going to explode, and we didn't even get to half the things I was hoping that we would get to. So I think maybe we'll have to have a part 2. And I know, Ksenia, I think you're going to for sure be joining us in Vegas for our NIL panels there, where we can talk about this more. And I'm sure folks will have all sorts of questions. So when we get this up, we'll try to have ways for people to contact and ask more questions. And hopefully maybe we can do a part 2 when we know a little bit more about Dartmouth down the road. And certainly if USC comes down, I think we've got to jump back on and do an update after that. But really appreciate you all starting to at least bring some of these issues up so that people can start thinking through them. Thank you for joining us.